Going to discuss some issues that sometimes come up on the bar exam for oil and gas. What type of estate and land a lessee in an oil and gas lien owns during a term on the lease? When a lessor signs a lease with a lessee oil company, the lease grants the company temporary interest in the estate, the rights to which revert back to the grantor upon termination of the lease. This type of estate and land is considered a fee simple determinable. It is also called a working interest. So that's fee simple determinable and a working interest in the mineral estate. And then the lessor has a possibility of reverter. Lessor, so a lessee has a fee simple determinable, and the lessor has a possibility of reverter. When the lessor signs a lease with a lease oil company, the lease grants the company a fee simple determinable. The estate and land following a fee simple determinable is a possibility of reverter, which goes into effect automatically after the termination of the fee simple determinable estate. In the case of an oil and gas lease, the lessor retains what is called a royalty interest. So the lessor has a royalty interest, and an NPR can be carved out of that. So an issue is one issue that might come up is whether the lessor has a duty to extend the lease based on the lessee's offer to make a delay rental payment. When a lease provides for delay rental payments, failure to make a delay rental time in correct manner may operate to terminate the lease. So the rule is a day late, dollar short with delay rental, it cuts. It's over. The lease is over. But you can have a paid up lease. But that's only if the language in the delay rental has an unless clause. If there's an or, so with an unless clause, it terminates immediately. With an or clause, it doesn't terminate immediately, but there might be some recourse with suit by the lessor. Lessor certainly does. So a lessor may make a demand of those delay rentals in the case the well has not been drilled or production has not begun, depending on the terms of the lease. Again, delay rentals are only to extend the primary term. So the way you get into the primary term, which is laid out in the addendum clause, is by starting production or within a specific amount of time, or and if you don't on the anniversary date, if you don't start production, you can pay a delay rental. And then once you get into the secondary term, there are various savings events that can occur. These savings events, well, the way you can get in is with the primary term ends as outlined in the addendum clause that discusses the duration of the lease for the primary and secondary term. One of the most common ways to get into the secondary term is to start production. Another way is to have one of the savings events, and that is a dry hole clause, a force majeure clause, and temporary cessation of production. So those are the ways to maintain a lease during the secondary term. So again, the savings clauses are the shut-in royalty clause, the dry hole, engaged in operation, cessation of production clause, force majeure, and pooling clause. And pooling can be modified by a pew clause. Coming back to the duty to extend a primary lease. So lessor may the issue is whether a lessor has a duty to extend the lease based on a lessee's offer to make a delay rental payment. Where a lease provides for delay rental payments, failure to make payment on time and in the correct manner may operate to terminate a lease. A lessor may demand the lease delay rental payments in the case that a well has not been drilled or production has not begun, depending on the lease terms of the lease. The lessor certainly does not have a duty to extend the lease beyond the primary term, regardless if the lessee's offer to make a delay rental payment or other payment. A lessor may agree to extend the primary term of the lease, in which case the extension should be signed and filed with the land records of the county clerk's office where the mineral lease is located, and any new signing bonuses must be paid to the lessor. So there isn't a duty, but if it does arise, it will arise. So if you sell the mineral estate, you own nothing. That's something else. The issue of what interest a mineral estate owner may retain if she or he has conveyed the mineral estate. In Texas, the mineral estate can be separate from the surface. Both the surface owner and the mineral owner may own a fee simple interest in their respective estates. Additionally, the owner of a mineral estate can convey the minerals and reserve onto themselves a portion of the mineral estate, and executive rights, a portion of the mineral estate without giving executive rights.